With the start of each new school year, it happens all over again. You bid the route, you get the schedule, you know the stops. It's predictable, it's consistent. You know the routine, you understand the rules. All that's true. But every year there are lawsuits that come about because a driver didn't follow the rules. Hello, I'm Peggy Burns. As a school lawyer for over 20 years, I've seen that serious harm to students can result from a driver's single departure from regular procedure. Ironically, that harm often occurs when the student wasn't even on the bus. Sometimes the drivers were held to be responsible for the consequences that followed. Sometimes they ultimately got off the hook because of one legal technicality or another. But most often, they simply lost sleep, sweated out a long courtroom battle, cried over a tragedy, and found their jobs on the line. The cases I'll talk about are presented for you to talk about. Each is a real example of how a driver's own actions or inactions brought about disaster at the bus stop or beyond. School buses are so safe. Surely we can prevent some of the calamities I'm about to describe. So as you watch, consider, what must I do to be sure these things don't happen when I drive? I'm going to tell you two categories of stories. There are more, but I'll save those for another day, another presentation. The first category is about student behaviors off the bus that you just plain know will happen and can prevent. I hope that even just that idea sets your mental wheels turning. The second category is about bus stops and schedules and the harm that can occur when transporters deviate from established rules. These are tragic situations, and I believe the stories will stay with you for a while. Let's start with a case about a diligent driver who had to juggle a couple of situations at once. I know you've been there too. This Louisiana driver became aware that two middle school girls were having a bit of a dispute. When the driver stopped at a district elementary school, April came hurriedly past other students to the front of the bus and reported to him that Fatonia was picking a fight. In fact, she punched at April right in front of the driver. A big girl, Fatonia would have been too much for the driver, who put both girls off the bus and stood between them on the sidewalk. He called to a teacher to tell the principal. This driver knew his limits. In the meantime, he determined he was blocking other school buses and that he had to move his bus. The girls seemed to have quieted down. Are you getting the picture? The driver got back on the bus, pulled it up a bit, looked back, and saw Fatonia on top of April. April's parents sued both the school district and the driver. The court held that the driver failed to meet his obligation to April when he put her off the bus into the very arms of her waiting assailant. His obligation? To provide supervision after the girl's exit from the bus. You see, the court ruled that he knew April needed protection from the bullying Fatonia. That's the key. He knew what would happen. Ultimately, because he didn't provide that supervision, the court found that the driver and the district together were responsible to pay for 50% of April's damages and costs. What were the options available to this driver? How could you have avoided all this? At a minimum, wouldn't you have radioed for direction?
Brian, can you separate those students?
After all, with the principal presumably on his way, would a few minutes of delay in moving the bus have had such serious and costly results? Could the driver have brought one of the two girls back with him onto the bus? What about asking the teacher to stay with the girls? Remember, and this is important, the driver was well aware of the lurking threat to April. You may not be held responsible for what you can't reasonably predict, but you'll be vulnerable every time when you know danger is likely. Now another story. In this next set of facts, consider what the driver knew. A sad irony about this next story is that this driver had the information she needed to keep her students safe, but she didn't use it. Here's what the driver knew. The special education students in her charge were to be delivered into the hands of a supervising adult. The driver had a clear directive: do not release unattended. What she did, however, in spite of what she knew, was to allow a female student to run off the bus and go into the school alone. She watched, too, as a male student dashed past her, off the bus, and entered the building. In fact, the girl went into a ladies' room and was followed by the boy who sexually assaulted her in that ladies' room. The court said drivers are required to use the bus as a safety device and to keep students in it until they can leave the bus safely. While that's a common mandate, this court noted the heightened importance of the bus as a safe haven in the case of vulnerable special education students. The lesson? Drivers must transport their students to a safe place. And a safe place is more than just a location. For the particular students in your charge, what makes for a safe discharge? Do you know? Do you insist that these safety factors be present at the time each student disembarks? I hope you're beginning to identify your role in recognizing a safe drop-off from an unsafe one. Sometimes it's tension between two students like April and Fatonia that keeps a location from being safe. Sometimes it's student characteristics like age, maturity, or the challenges of disabilities that can have significant impact on safety. Perhaps more often, though, safety is about the physical features of a place, like view obstructions, shoulder width and composition, absence of sidewalks, traffic speed and volume, stoplights and stop signs. Your supervisors have spent time and carefully considered these physical features in selecting stop locations. They've incorporated issues presented by urban and rural routes in their planning. But if you let students disembark at an unauthorized stop, you're making an on-the-spot decision about the safety of the stop. That can lead to tragic results. Here's a case in point. An Illinois driver accommodated a high school student's request to be dropped off across from a service road leading to the rear entrance of the high school. The bus company's policy allowed a driver to honor student requests for drop-off if the driver could do so safely. But it was still dark that day, and the place selected had minimal road shoulder, composed of loose pebbles and grass, and no sidewalk, crosswalk, or intersection. There were woods and ditches along the side of the road. The student took about 1.5 steps into the northbound traffic lane when a van struck him. His high school career ended with brain damage and a multi-million-dollar judgment against the bus company. And the driver had to endure lost sleep, participation in the 3 years of litigation against the company, and countless tears over the tragedy. Unlike this contractor's policy, most school districts and bus companies don't allow for driver discretion even if a student or parent makes a request. I'm thinking, too, of policies like checking to be sure the student is a rider or abiding by schedules.